as an estate planning lawyer, I get to deal with usufruct a lot. So I'm going to go through typically what comes up when we have a usufruct conversation. A lot of people come in the office, they chit chat and they say, I want to leave my spouse usufruct of what I have. And they have no idea that there's alternatives to that. But let's say all that's been explored and they want to get their wills done, they want to leave their spouse usufruct. So there's some decisions that you have to make, and I'm going to go through some of the practical consequences of the usufruct decisions that get made, particularly with married couples. So one option, kind of the just general generic usufruct, couple writes wills, they each say, I leave my spouse usufruct. So let's say husband dies first. Now, if it was just that generic usufruct, and then after the husband dies, the succession gets complete, the wife's usufruct is established, she owns her half, she has the usufruct of his half. If she wants to sell the house, she can't by herself. She has to get the permission of the naked owners. In the husband's will, he probably said, I'll leave my wife usufruct of everything I own, and I name my children as the naked owners, because every time you leave someone usufruct of something, you have to state who the naked owners are, who's going to get it when the usufruct terminates. So under the regular usufruct, I leave my wife usufruct, name my kids as naked owners. When the surviving wife wants to sell the house, or the surviving husband, whatever the case may be, they'll have to get the permission of the deceased spouse's children, naked owners, and so which means they have to agree or sign off on the sale. Sometimes that can cause problems. So in order to solve that problem, some people say in their wills, I leave my spouse usufruct, and I give my spouse the authority to dispose of non-consumables over which they have a usufruct. So there's a provision in our Louisiana law that its intention is to give the surviving spouse the ability to sell things that they have the usufruct of. Now, if that's granted in the will, succession probate takes place. Wife now has her usufruct with the power to dispose. She goes to sell the family home. Even then, most title examiners still will require the children to sign off on that sale, even though the will gave that surviving spouse the power to sell without having to get the children's permission. So still some problems there. So sometimes, take it a step further, we'll say I leave my spouse usufruct, I give my spouse the authority to dispose of non-consumables, and name my children as the naked owners. However, my children's naked ownership interest will be held in trust with my surviving spouse as the trustee. That usually solves the problem. So now husband dies, succession takes place, wife has usufruct, children are naked owners, but their naked ownership interest is held in a trust with the spouse's trustee. So when she goes to sell the house, if the naked owners need to sign, the wife is really signing on behalf of the naked owners because their naked ownership interest is in a trust and she's the trustee. That's often called a testamentary trust. It's a trust that was created in the married person's last will and testament. So those are, that's just an initial conversation about the form of usufruct that you leave your spouse. The other important decision is what's going to be the term of the usufruct. So typically, married couples write wills. I leave my spouse the usufruct for life. So it's usually a lifetime usufruct. Sometimes it says, or the spouses make a decision, I leave my spouse the usufruct until the earlier to occur of my spouse's death or remarriage. So what that means is if the surviving spouse remarries, the surviving spouse has to settle up with the deceased spouse's naked owners, typically children, and that usufruct doesn't last beyond the marriage of the surviving spouse. An important note, if you're wealthy and there's the potential for estate tax concerns, that usufruct, if you leave your spouse usufruct of what you have, really should be for life and for life only, because that allows some special what's called Q-tip elections to be made on your estate tax return, allowing for no tax to be paid, no estate tax required to be paid, within 9 months of the first spouse's death. It can be deferred and potentially even avoided until after the surviving spouse dies. So special tax provisions there. If you've accumulated some wealth, and there's the potential for the 40% estate tax. So also know that you can accomplish similar things, or maybe there's other alternative ways. Just know that there's alternative ways to leave things to your spouse and kids. It doesn't have to be usufruct. Usufruct is really a Louisiana only thing, and so we have other options, just like everyone in other state has other options on how they leave things for the benefit of their family. So make sure you explore all of that before you start making some decisions, and have fun with all that. By the way, never known a word that has been mispronounced more than usufruct. This is going on YouTube, and if I say some of the ways I've heard it come out of some people's mouths, you couldn't keep this video on YouTube. So we'll leave it at usufruct. Have a great day.